Hello, I'm Andy Siegel. I'm the senior trial lawyer at Siegel Coonerty. We are a personal injury and medical malpractice law firm here in New York City. Today's video tip, it's the anatomy of a trial. Once you hire a lawyer, sometimes these cases resolve during the course of litigation. That's known as the settlement. There are times, though, that your case has to go to trial. We have in-house trial lawyers here at Geller, Siegel, Coonerty, meaning we are the guys that take your case to court. In that event, you should know what to expect if we do get into that courtroom. The first thing that'll happen after, again, the jury is selected, is the judge will give an instruction. He'll tell the jurors and the litigants to the lawsuit how the case will proceed. The next thing you can expect to occur are opening statements. The plaintiff, the person bringing the lawsuit, is the person who does their opening statement first. The reason why is the plaintiff has what's known as the burden of proof, meaning we have to prove our case before defendants have to defend the matter. After the opening statement is done by the defense counsel, then the plaintiff puts on their case, meaning, again, we have the burden of proof to prove the different elements of your case. And we do this by witnesses, we do it by exhibits, we do it by medical records, by many different vehicles. It's all known as evidence. After the plaintiff puts on his evidence, we sit down, the judge will ask us, plaintiff's counsel, do you rest? We say, yes, Your Honor, we rest. Then it's the defendant's turn to put on their defense in the case. Sometimes they'll put no defense on at all, meaning they have no obligation. If they don't believe we've proven our case, they can go, not put on any witnesses, and tell the judge, we have no witnesses, or we believe that the case should be dismissed, and then they'll give their legal arguments. More times than not, though, the defendants will put on witnesses to defend their case. After those witnesses go, and again, for each witness you should know, there's a direct examination of the witness, meaning the attorney who called the witness asks that witness questions on direct exam. That attorney then sits down, then the opposing attorney gets up and does what's known as a cross-examination of that witness. That attorney then sits down. Then the first attorney who did that direct exam has an opportunity to ask that witness again, and sometimes judges let that other attorney who did the cross-examination to again ask further questions. In any event, after the witness is over with, after the defendant rests, there comes a time where there are what's known as closing statements. Unlike opening statements where the plaintiff goes first, in the closing statements, the defendant goes first. The defendant will give his closing statement. Sometimes it's a summary of the evidence, sometimes it's a legal argument, sometimes it's both, and then they will sit down. Then the plaintiff, counsel, me, if I'm representing you, I'll give my summation. My summation generally is not to tell the jury what the evidence proved, but rather to analyze what went on in the courtroom and why this case should be found in your favor. After that, it's jury deliberation, then a verdict. It could be a plaintiff's verdict or it can be a defendant's verdict. That's the anatomy of a trial. This is Andrew Siegel. If you need further explanation, give me a call, 212-532-0532, and I'll answer all your questions. Thank you.